to some of the other specialty application forms. So we already talked a lot about applications, but there's more. So there used to be a single-page form called the notice of motion. It was strangely used for all kinds of things. You know, people were using it to seek interim parenting time. People were using it to get vacations. People were using it to get DNA tests or to settle orders, get disclosure. That form was very confusing, and it's honestly not really clear what you're supposed to use it for really back in the day. So now they've totally done away with it. It's gone. And instead, we're getting a whole host of other forms that are very interesting. We'll go over all of them in turn. So this is where you kind of already filed your first application, you know, the one that we just spent an hour talking about. And you've got a whole bunch of other smaller things that you're asking for, not necessarily small, but like a bundle of specialty things that you're asking for. There's a specific form for something called a case management order that could be either with notice to the other side, meaning they know about it, the other side knows about it, or you could do it in some very distinct circumstances without notice. We'll get into that. There's a protection order application. There's something called a priority parenting matter application. There's a prohibition of relocation application. There is also an application for just enforcing things. Those are like all the applications. And if you've got one of those and you're making a response, there's a written response application form, which is in Form 19. So usually what will happen is someone will file one of the top forms. The written response will be done up. And then there's a court appearance on the matter and there's some kind of hearing. It could be a hearing or a trial. So essentially the judge decides at that point. So let's get into the first one, the case management order, Form 10. So the way to think about this form is that you're using this form for some kind of administrative order. And what is an administrative order? This is where it's a process type thing and not a substantive type thing. Perhaps we should dial back and talk about what's a substantive type thing. Substantive type thing is where you want parenting arrangements, you want child support, you want spousal support. Those are substantive orders based on evidence and, you know, something to do with kids, something to do with money, that kind of thing. Case management process type orders, this is where you want, you know, to appoint a lawyer for a child, you want to correct a name on, you know, the style of cause. And I'll go through them. So you could ask for access to a file, management to a file. You might want to transfer a file to another registry because everybody has moved. You might need to correct the date of birth because someone listed it wrong one time. You might be seeking some type of financial or document disclosure. You might want to be getting a DNA test. You need to adjourn a court appearance because, you know, you're now booked in for surgery, can't make it. You might want to settle terms of an order. You might want to get a conduct order, a views of the child report, a Section 211 report. You might want to set aside a subpoena because your witness can't make it. Or you might want to cancel an order that was made ex parte, which means it was in the absence of a party. So the case management form, application form, basically has a checkbox for each of these things. And depending on what you're doing, like, oh, my name was spelled wrong on the order, then you would check off correct file document and list out what exactly you want done. And then there would be a court appearance set to deal with that one thing. Or I want a DNA test, you know, for this child, you know, that would be something you would check off on the form. And then there's a specific mini hearing about, you know, should you get a DNA test and who's going to pay for it and that type of thing. So these are case management orders. Now, these orders can be made at any time. It's usually generally to manage a case in some way, to prepare for the next steps. Now, usually they're made with notice to the other party. So if you're trying to set aside the trial date, obviously the other side's going to need to know about this, right? And to explain, you know, whether or not they agree with it, or maybe they don't. Maybe their witnesses can only do it at that day, so they shouldn't move it, or maybe they've waited long enough and the thing is urgent, so they oppose. So that's why generally these case management orders are made with notice to the other side. Now, obviously, if the other side agrees, you can do it by consent and choose to have a judge review it without needing to everyone take a day off work and go to court. And then usually by giving notice, you're serving the other side with an application, a copy of that application, and all of your supporting documents which have gone in with it. Say you have surgery scheduled for the trial date, you're seeking an adjournment, you might have a doctor's note saying, yes, your surgery is scheduled for that day, so you can't go. Now, in rare situations, you can use Form 11, where you don't want to give notice to the other side, or somehow it doesn't make sense. For example, if you're looking for a substitutional service, so obviously you couldn't find the other side in the first place, and you're looking to avoid needing to personally serve them because you don't know where they are, and the only way you can contact them is through, I don't know, Facebook Messenger or email or whatever, it clearly wouldn't make sense in that instance to serve them with the application because you don't know where they are. So if you're looking to modify service, alt service, you're waiving some kind of requirement, under very rare circumstances like the ones listed, you can do this without the other side knowing, sometimes for practical reasons, like you don't know where they are. In that case, you would fill out Form 11. The judge will then, decide whether or not it's valid or not valid and whether or not to grant the substitutional service order. Any questions so far about case management orders before we move on to the next big topic, which are protection orders?
Thank you, Karen. There are no questions at this time.
Okay. Protection order forms. This is Form 12. Let's talk a little bit about what these things are, first of all. Protection orders are orders that protects one family member from another family member if there is some risk of family violence. The highlight here is risk. There doesn't need to already have been family violence. Sometimes there is, but it's applicable if there is a risk of family violence. So in putting together this application form, you will be seeking some type of condition on that other family member. No contact, don't come to my work, don't come to my house, some type of communication requirement, maybe no communication, maybe communication just about the kids. It is a very serious criminal offense to disobey or breach any conditions in a protection order. You'll be criminally prosecuted for such breaches. Now, the orders don't last forever. Sometimes they're for a specific duration, like if the judge should say, yep, it's an order valid for 3 months or 6 months or whatever. If there's no specific end date on the face of the order, they automatically expire after a year. So bear this in mind. They're not forever. Your client will have to apply for a renewal, like not at the 1 year mark, like sometime, like month number 9, if your client wants to have this renewed, you should be seeking a renewal of the protection order. So parties can apply for themselves and the child, or they can apply for on behalf of another adult. This might happen, for example, if there's a vulnerable adult in the family, an elderly person or someone who's otherwise not able to bring the application on their own. Protection orders. As a support worker, helping someone put one of these together, there is an aspect of the box where you check off, are you applying with or without notice? Again, if you're applying with notice, it means right away, before going to court, the other side is going to be served with a copy of this application and read in great detail what your client's problem with them is and what your client's looking for. Obviously, this in many situations would exacerbate the situation, create more conflict, and perhaps create a dangerous situation for your client, especially if the other side is a dangerous person to begin with and you're seeking a protection order. So as I said, normally you do need to give notice to the other party by serving everything to them because it's fair for them to be able to make a fair answer in defense, right? Like the courts, these are very serious orders. if at all possible, the court wants to hear from both of you to see like what everybody says, test the veracity of these claims, etc. So, but under very specific circumstances, it can be made without notice. For example, if there is imminent harm or danger coming to your client, or providing some type of notice in advance would probably create the risk of real danger or violence or some type of serious consequence. Like, you know, if the other side knew, they'd probably come and, you know, do some harm to you right away. Now, getting a without notice application is actually pretty common in protection order cases, because if it's serious enough for your client to be seeking one, there is probably some risk of danger of the other side, you know, knowing right away and the order is not in place. So oftentimes the court will allow the without notice thing to go ahead, but make it a very short protection order in duration and say, fine, you'll get the order, but then you need to serve the order to the other side. The other side will know about it, and everybody then will come back in 2 weeks to have a full opportunity to argue about it, to see if a new order should be renewed for like the next year. So that's kind of how typically I've seen it dealt with in court, where you ask for it without notice, they'll know. I mean, the other side obviously has to know that there's a protection order out on them. They will know, they'll find out, they'll then have the opportunity to like answer that protection order, but the order is already in place for a kind of a limited time. So we do have a couple questions here. If a protection order is granted in family court, is it police enforceable? All protection orders are police enforceable. They have the full force and effect and are enforceable under the criminal code. And like I say, a breach is a criminal code offense. Travis's question, is it the abuse for the children or the parent? The family violence could be to any like person in the household. Even witnessing family violence, in some situations, the court have thought of it as a protection concern and a type of violence kind of vicariously for the children. So yeah, all of this is kind of part of the protection order and kind of the detail that you can get in when you explain why you want this protection order. So let's take a look at the protection order application itself in some detail. Schedule 1 affidavit must be signed with a commissioner for taking affidavits. You will note with the other applications, there's no requirement that it be sworn evidence. When you put things into, obviously you need to be telling the truth, okay? Your clients cannot lie on a court form. But there's a specific requirement, because the protection order application is so, it's an infringement on the other person's, you know, liberty and persons. These are very serious allegations. Your client must be willing to swear or make an affirmation in front of a commissioner that everything they put in there is true. So the form, at the bottom of the form, you need to bring your client, or your client needs to go with the form to either a lawyer, a notary, or back to the registry to have their evidence sworn in by a commissioner. So understanding that there is, and I think Travis asked you a question about, well, what if I made a mistake? They better not be making a mistake on this form, because it's so serious and it's sworn evidence. It so often when there's a protection order request, and we'll touch on this on the next slide as well, there might be a matching criminal file. You know, your client might need to testify in criminal court about whatever incident occurred that led to both the request for a protection order and the criminal situation that's going to trial. And your client, you need to be so cautious in supporting your clients through this. And it's a lot of pressure, but they can't give competing evidence or inconsistent evidence. And where this can go wrong is usually the evidence is collected at many stages if there was an incident. You know, the police would have attended at the house. They would have given it a verbal, you know, statement to the police back on day 0, right? Like when the police showed up, they would have said, oh, this is what's happening. This is why I called the cops. So there's like the 911 call and what they said there. There's like when the police arrived, what they said there. If they then get interviewed by the police back at the police station in the days to come, there's that statement there. And now this is like the 4th potential statement that they're making in the eyes of the law. And even if I asked like any regular person to retell a story about something that happened at lunch, you know, 3 days ago, every retelling at the end of the day is going to be, you know, a bit different because, you know, your memory changes, the way you present something change. Be so cautious when, you know, you don't want to prejudice your clients. You don't want to, prejudice your client's case. You don't want to make it so that they've provided an inconsistent evidence, you know, at the criminal hearing and be found not credible. So this is where you walk the fine line between being vague and putting in too many details, which is somehow maybe inconsistent with what they told the police in the first place. So it's kind of a very, you have to be, if as part of this protection order application, your client is stating in quotation, at that point, he, you know, grabbed my hair and said, I'm going to kill you. And those are the exact words, and your client is committing that statement in the affidavit. That better be also what they said to the police. Otherwise, it's better to not put things in hard quotations to say that, you know, the statement, then you got to be careful saying in your protection order, then he threatened to kill me, you know, and not put things in specific wording, which then your client might be cross-examined on, you know, later on because that wasn't exactly, you know, what was said. So just be super duper careful in filling out this form, given, you know, the circumstances. Now, as part of the form, of course, you can ask at paragraph 3 here, you know, I don't want the other side to go to my house, my place of employment, etc. You want specific kind of communication clauses you can put there. You have concerns about, you know, guns and explosives and firearms. You can put your explanation of your concerns there. You know, you want as much information in here as your client really, if they have these concerns, obviously it's important for them to be granted this protection order. Again, this is where you want to be as factual as possible without somehow creating inconsistent statements between what they told the police and what they told, you know, the investigating officers at the station. And this is where also paragraph 17 and 16, where you talk about the mental health concerns of the other party. Paragraph 17, where you describe any of those situations that are create the risk of family violence. Honestly, this is such a tough form to do. And, you know, it's about coming to really setting aside quite a bit of time to work with your clients on this form, understanding that answering 17 and 16 for most people would be extremely traumatic. It's 100% a trigger. I mean, if you just read it, the things that they have asked you to describe, like, you know, it's really tough having gone through. If you have some of those things to talk about it, you need to give your clients lots of space, like, you know, and maybe, you know, if it's beyond your training and experience, to work with clients about filling out paragraph 17, you might need to involve your Stop the Violence counselor or someone else who, could act as a support with that training and experience to support someone answering question 17, because it's such a tough thing to write about and to share, not only with the strangers in the room, but also with the court, and understanding that at some point, the perpetrator of these things will get a copy of this form. That's, writing 16 and 17 is very, very difficult. So, just have to be super mindful of that. Travis has a question. Is there a time limit on completing all these forms? Like when you pick them up, you have a week to complete? No, the forms are always available. I guess the only time limit you run up against is unless you filed it, you're not getting it. So, the longer you delay your child support application and spend the most time, putting it all together, the longer the delay to get to court to, get it done. Or the protection order is probably more pressing, because if there's imminent danger to your client, which this is why you're filing the protection order in the first place, you're not getting your protection order until you've completed your materials and handed them in. So the time limit that you're running up against is just whether or not the delay prejudices your client. The other time limit is perhaps if you were the responding party and you were the one doing the counter to the first application. Of course, then you're court bound by the days you've been served to get that material in on your counter application. So paragraph 25 is very much akin to 16 and 17. You have to describe the incidents of family violence that's already happened, any trauma, attach police reports and photos and doctor's notes. This is a big, big, big process. You're committing essentially your witness list on paragraph 25. You can see like the who witnessed it, who was involved. There is a lot to completing this portion. Again, be very mindful of whether or not you're raising inconsistencies between your client's present evidence and the evidence they gave the police. You then would have to attach all of these things as exhibits. So, getting doctor's notes and police reports would be the difficult one to find, because that requires a special order for disclosure before the police will release that document to you. And they honestly might not if it's an ongoing investigation. So some of these things are going to be difficult to find and get your hands on in order to have them handed in. Maybe the best you can do is the police report file number, and which officer was involved on that day if it was a recent incident. Otherwise, you'd have to seek a specific police disclosure order, which you have to get the case management form to do and serve that on the RCMP, big process, So do your best on paragraph 25. And again, recognize that this is going to be extremely hard for someone who's already lived it to then have to, retell it. Okay, protection order forms done. Next up, applications about priority parenting matter, form 15. So priority parenting matters are very specific. They're usually decisions about the children where not all our guardians are in agreement. And if there's some specific rush to know the answer to that question, and you want to separately decide this beyond the usual parenting schedule, etc., but something must be done quickly for some specific reason. So let's take a look at when those apply. Oh, we have a second question about the protection orders. Would a protection order form be court ordered? Not sure, Travis, specifically what your question means, but certainly I've seen judges suggest to parties that they might wish to make a protection order application. If even the judge recognizes there's family violence, they'd be like, why aren't you filing a protection order request? Okay, so back to priority parenting matters. You can make sometimes these with either short notice or no notice at all, if again, there's some real risk of serious consequences if the other party is given notice. Here, it would be more of like an example would be a flight risk. You know, the other side has threatened to leave the jurisdiction with, you know, your kids. And obviously, if you told them about it, they won't wait to leave. They leave now. So where there's a real risk of some type of serious consequence if the other party is given notice, this is where you might want to do the without notice option for a priority parenting matter. Here, though, if you want to do it without notice, you must also complete Form 11, where you seek the case management order without notice. So, what are the usual topics covered by Form 15? Health treatments if delay will result in risk to health. Passports, where you're applying for a passport and they have to go somewhere, school trip, something like right away, something like that, and the other person is refusing to sign your passport application. If the kids are traveling or participating in some activity and that the other parent saying, no, you can't go to soccer camp and camp starting, you know, in 4 days, that type of thing. If there's never been a court order and the other side's trying to like move with the child, this is, you know, part of that earlier example where like someone is trying to like take the child and leave the jurisdiction in some form. And obviously it's going to have an impact on the child's relationship with the parent that doesn't move. Some type of wrongful removal of a child. This is like the international child abduction type situation, or abducting them to Alberta without consent of the one parent, that type of thing. Some types of interjurisdictional issues and certain kinds of like emergency ministry matters, either talking about doing an emergency family application that's going to prevent a removal of the child, or to encourage the return of a child. And those typically you'll know about because the ministry is initiating it. So these are the very, very limited circumstances where you can use Form 15. It is not about interim child support. It is not about interim spousal support. These are like very serious, time-limited parenting issues mostly.